You probably think the facts are too stacked against you. You confessed. There's evidence, maybe even a recorded statement. But in California, the outcome of your case doesn't just hinge on whether you did it. It hinges on how the prosecution handles your case. I'm Nana Knight, and I'm a criminal defense attorney here in California, and I've helped clients walk free in cases where everything should have led to a conviction. This video breaks down exactly how dismissals still happen, even when you don't believe you're innocent, so you know what's possible before you take that deal you might regret forever. Let's talk about police misconduct. And here's the truth most people don't realize. If the police screw up, you can use it to your advantage. California law says that they have to follow certain rules, like when they can search you or when they need a search warrant and how they collect evidence. If they cut corners, your whole case could collapse. Take this. A client of mine got pulled over in Santa Clara County for rolling a stop sign. No big deal until the police officer decided to search his backpack and found a concealed weapon and arrested him for carrying a concealed weapon. But here's a twist. The officer had no legal reason to search that bag. No consent, no probable cause, nothing. We filed a motion to suppress the evidence and the judge agreed. Case dismissed on the spot. The weapon was real, the search was illegal, and in the eyes of California law, that changes everything. Let's talk about evidence. You might assume that if they have the evidence, you're done. Wrong. Evidence gets thrown out in court all the time. Why? Because it's often unreliable. DNA gets contaminated. Witnesses get it wrong. Body cam footage goes missing. Breathalyzers break or aren't even calibrated properly. Example, I had a DUI case where the breathalyzer machine hadn't been serviced in over a year. When I brought that to court, the judge tossed the test results, and without that, the case had no legs. Gone. Or take eyewitness testimony. People think that they saw something until you show them the actual footage. In Santa Clara County, a client was recently accused of stealing a watch. The security guard swore he saw my client put it in his pocket. But guess what? The footage showed otherwise. We showed the tape. The DA dropped the charges before trial. So yeah, evidence isn't perfect, and sometimes poking the right holes in it can make the whole thing fall apart. Wrong charges. Here's something most people miss. You can be charged with the wrong crime, and if that charge doesn't hold up, the whole case can unravel. Let's say you get into a shoving match at a bar. No one's seriously hurt, but you're charged with a felony assault charge, right? That's pretty serious. But here's the thing. Under California law, if there's no real injury and you acted in self-defense, that might not meet the legal definition of felony assault. So a good defense attorney can file a motion to get it dismissed. In Santa Clara, my client was charged with felony theft for allegedly stealing a bike. Turns out the bike wasn't even worth $950, which is the cutoff between a misdemeanor and felony theft. We proved that. And guess what? The felony charge was dismissed. The misdemeanor was eventually dropped. No record. Sometimes the win isn't dramatic. It's procedural. California law is full of technical rules. Deadlines, notice requirements, motions. So if the prosecution slips up even a little, your attorney can jump on that. A client of mine in San Jose had a vandalism case delayed over a year. The court rescheduled it. The DA wasn't ready. We invoked her speedy trial rights and we filed a motion. The judge agreed. The case was dismissed. There's also something called Penal Code Section 995 motion, which lets you challenge the case early before trial after a preliminary hearing if the evidence isn't just strong enough. It's like pressing delete on your charges. These legal tools exist for a reason, and if the system messes up, it's your right to use them. Here's the final way to get a case dismissed, and it surprises people the most. Sometimes the prosecutor just says, forget it. Why? Because they're overwhelmed, because the jails are full, because they would rather move on, focus on a far more serious case. And if you're willing to make things right, they might be willing to dismiss your case entirely. Let's say you're facing a shoplifting charge. First time offense, you agree to take a class or do community service, right? That's called a diversion program. And if you complete it, the case goes away. No conviction, no criminal record. Your arrest is usually sealed. I've had clients in San Jose and all over Santa Clara County walk away clean even when they admitted guilt. Sometimes the prosecutor will dismiss a case just because it's the fair thing to do. I had a college student caught drinking underage. She risked losing her scholarship. When we explained her the situation, she took an alcohol class and the DA agreed to dismiss the case in the interest of justice. Not every case ends that way, but if you have a lawyer who knows how to negotiate, you've got a shot. And why this matters. So, can you get your case dismissed even if you're guilty? Absolutely. California law isn't just about punishment. It's about process. And when that process breaks down through bad police work or weak evidence, overcharged crimes, missed deadlines, or smart negotiation, you win. Not because the system's broken, but because it's working exactly how it's supposed to. If you want to stay one step ahead of the law, subscribe now and hit that like button. It helps more than you know. And if you want to go deeper on how to protect your rights in California, click on the next video over here to learn more about how you can get your case dismissed in California. Thanks for watching, and I'll see you in the next video.